Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you're having a great day. For today's stream, we turn our attention to Leah Remini versus the Church of Scientology. Leah Remini is an actress and former Scientologist who has been quite public in her dislike of Scientology, running various podcasts and appearing on other people's shows to express her distaste for Scientology. She accuses the Church of Scientology of harassing her, stalking her, and otherwise harming her through defamation and otherwise, in a lawsuit that we have discussed in the past. So far to date, we have read the original complaint, Scientology's reply, and Leah Remini's reply brief to that. Overall, I thought Leah Remini's case did not look very good. It looked likely to be dismissed, but there might be a few areas of hope. Well, the court has provided a preliminary ruling on the anti-SLAPP issue as to some of these issues on the moment of their ideas. So we're going to see the degree to which the court agreed with me or not as to which parts they found workable or not. So we'll see how close I got versus what the court said. So that'll be fun. Here is what the court writes. Again, this is all in a preliminary posture because we're in response to an anti-SLAPP. SLAPP is a strategic lawsuit against public participation. Scientology accuses Leah basically of trying to go after them in an invalid way for free speech. And if they're correct, then they not only get the case dismissed, they get damages. So this is a preliminary motion that speaks to whether or not there's enough evidence to suggest this is a legitimate claim versus a mere claim to harass. So we could still have other motions to dismiss along the way, and we still could have other summary judgments, but this is what we have for as far as it goes. So this is what the court thinks, at least to this point. Leah Remini brings this action against David Miscavige, the Church of Scientology, and the Religious Technology Center. Remini is a former Scientologist who alleges that the defendants have undertaken a campaign to ruin and destroy her livelihood after she publicly departed in Scientology. Very publicly, one might note, which is also part of the problem, right? It's like you got to kind of have your cake and eat it too. It's when you go out and sort of make yourself a figure, you got to accept some of that back. That's the whole idea about public figures. So like you can't invite the confrontation, to which she certainly did, at least in part. That isn't to say that what she's doing is invalid, and it isn't to say that what Scientology is doing illegal. It is just simply to say that, you know, in the first instance, if Scientology fights back, that's to some degree to be expected. Plaintiff alleges that she, her friends, and family members have been stalked, surveilled, harassed, and more by persons who are controlled by and coordinated by Scientology. The coordination and control aspect was a real problem for me in sort of this. How do you know it's controlled by Scientology? What's your evidence for this? Seemed kind of sketchy to my mind. Plaintiff now brings this action for civil harassment, stalking, intentional infliction of emotional distress, tortious interference with contractual relationship, intentional interference with prospective economic advantage, defamation and defamation per se. There was some in there that might be possible, but a lot of it didn't seem workable. Defamation by implication, false light, and declaratory judgment. So of these causes of action, I was skeptical of civil harassment, stalking, because there wasn't really any evidence that I could see that these were things that were being done by or at the direction of Scientology. They seemed too speculative to me. Intentional infliction of emotional distress, there were some possibilities. Tortious interference, kind of dismissed that one myself. Intentional interference with prospective advantage, kind of dismissed it. Defamation per se, mostly dismissed it. There were a few in there that maybe could survive, but I had serious question marks. Defamation by implication, kind of the same thing there. False light, you would expect to sort of disappear in the defamation cause of action. And declaratory judgment, which, you know, they did bad things. So that's sort of what my assessment. The Church of Scientology now moves to strike portions of the amended complaint pursuant to the anti-SLAPP. SLAPP is strategic lawsuit against public participation. In other words, you're suing us not because we really did anything wrong, but you're really suing us just because you're mad at the words we said. And, you know, we have the right to the words, so you can't sue us for being mad. The plaintiff opposed and defendant replied. Okay. On January the 3rd, the plaintiff filed a motion to strike portions of the thing. Okay, we read that. Based on new findings, the court concludes, held a hearing and so forth, and we grant in part and deny in part. Okay. So let us say what we have. Plaintiff's objections. Plaintiff's unnumbered objections to the declaration of Farney are overruled. Fine. On January 3rd, they filed a motion to strike portions of the reply, or in the alternative, objections to portions of the reply. Plaintiff takes the motion with the new evidence. The general ruling on motion practice is that new evidence is not permitted with reply papers. The inclusion of additional evidence with reply should only be allowed in the exceptional case and permit the other party should be given an opportunity to respond. However, it is permissible to submit a reply declaration that fills in gaps created by plaintiff's opposition. The court has reviewed and considered the reply papers and declaration as well as the motion to strike. It concludes the evidence presented fills in the gaps related to the opposition. Plaintiff was also given ample opportunity because it's not new evidence. I don't remember stating an opinion on this issue. So the court and I don't remember stating an opinion on this particular detail, so we'll let that one pass. Defendant's objections to the declaration of lien singer are overruled. Other objections are overruled, and those are all overruled. Okay, so I don't remember having an opinion on whether the new evidentiary questions, so I'll let those move on. The relevant law permits the court to strike a cause of action arising from an act in furtherance of a defendant's right of freedom of speech or petition, unless the plaintiff establishes that there's a probability that they'll prevail. In other words, you can't sue us just because you're mad at the words. You have to actually have, a cause of action. Learbert says no evidence, but how would you get that? Hire a PI to follow people who are following you to see if they're Scientology? I don't know how you would get that evidence, but you can't just operate on pure speculation. You can't just pure speculate your way into this. I don't know how you would go about getting the evidence. All I can say is you don't have it. How you would go about getting it, I can't speak to that. I don't know. I'm not really an experienced trial lawyer in this way. I'm much more focused on appellate law, so I'm not sure how you go about that practically. The anti-SLAPP procedures are designed to shield a defendant's constitutionally protected conduct from undue burden of frivolous litigation. The anti-SLAPP statute does not insulate defendants from any liability for claims arising from protected rights of petition of speech. It only provides a procedure for weeding out meritless claims. That's basically correct. Resolution of the anti-SLAPP involves two steps. First, the defendant must establish the challenged claim arise from activity protected. In other words, you must be suing us because, it's protected speech. If the defendant makes the required showing, the burden shifts to the plaintiff to demonstrate the merit of the claim by establishing a probability of success. The California Supreme Court, and of course this is a matter of state law, so your state will vary massively, has described the second stagement as a summary judgment-like procedure. Fine. The court does not weigh evidence or resolve conflicts. Its inquiry is limited to whether the plaintiff has staged a legally sufficient claim and made a prima facie evidence. It accepts the evidence is true, fine, and evaluates the defendant's showing only to determine if it defeats the claim as a matter of law. So we're not going to weigh the evidence. We're simply going to see, is there actually really a claim here? Fine. Like an anti-SLAPP is just a special motion to dismiss, which they say it's summary judgment-like, but what's the difference? Either way, you're trying to say, is there sufficient acts to go to a jury? So, whatever. All right. Leah Remini is a two-time Emmy Award-winning producer and actress and New York Times bestselling author. She starred in the television sitcom The King's and Queen. Defendant David Miscavige is an LA resident and the de facto leader of the Church of Scientology. Miscavige, now they're citing here, of course, the first amended complaint. So I would like to take note here. The court is not saying these things are in fact true. The court is just assuming them to be true because that's how they work, right? We assume the facts, and I emphasize the facts that Leah Remini have to offer are true. That is the whole point of the motion to dismiss / the anti-SLAPP / the summary judgment, right? What are the facts? Are there facts? So we accept her facts as true. We do not have to accept her conclusions as true, and we certainly do not have to accept any legal conclusions she has as true. So if she wants to say David Miscavige is this, then, you know, okay. But she has to have some basis for that conclusion or some basis for that belief. So she has to have some reason to say it. You know, something she saw, witnessed, observed, knows, is publicly available knowledge, some reason to believe it to be true. There's some reason to believe David Miscavige is the head of Scientology. That's pretty well, that's well accepted enough for the purposes of our motion. So the court is not saying these things are true, just that they appear to be true and are not obscenely, frivolously stupid. You know, if you say, well, you know, the sky is black, I'm like, well, you know, I don't have to accept that fact as true because you're obviously blind. Miscavige took control of the Scientology in 1986 after the death of the founder, L. Ron Hubbard, who will be coming back any day now, don't you know? Miscavige is responsible for ensuring the standards, policies, and ethics of Scientology are carried out. Well, that's one way of phrasing it, I guess. Defendant Religious Technology Center is also a California corporation doing business in Los Angeles. It is the principal management, security, and enforcement entity for Scientology. It owns, administers, and enforces certain IP rights and receives licensing fees paid to those rights. RTC also oversees and directs defendants' investigations and policing operations, monitors members' behaviors, and handles matters concerning discipline and punishment. Defendant Miscavige serves as RTC's chairman of the board, through which he controls and directs the activities of the defendants. Okay, again, these are all things alleged to be true, and where I suppose are assuming to be true for the purpose of our current discussion. Defendant Church of Scientology is a California corporation with a primary place of business and headquarters in Los Angeles. CSI, the Church of Scientology, is a licensee of Scientology's intellectual property. Interesting. Who in turn licenses the IP to numerous other Scientology affiliate entities and organizations. Like RTC, CSI is controlled and directed by David Miscavige directly and through other officers who report to them. Fine. Allegations in the First Amendment complaint. Okay, what did Leah Remini say that Church of Scientology did? What is she complaining about? In the literal sense, what is she complaining about? Starting in the 1960s and continuing on to this day, the plaintiff alleges the Church of Scientology has instituted a series of retaliatory activities to be taken against individual, organization, businesses, or government that Scientology deems to be an enemy. And she has some writings about that, like really early on from Scientology's origins, like in the early 60s. But some of the things as it applies today were a lot less Under former Scientology directives, enemies of the church, so-called suppressive persons, HALA, are deemed to be fair game for retaliation. This leaves them to be vulnerable for harassment, stalking, and other attacks. Don't harass people. Or stalk them, really. One might become a suppressive purpose by, for example, leaving Scientology, making public statements against it, or through consuming media critical of the church. Through various means, the church and its affiliate entities seek to obliterate, silence, and ruin utterly any individual who is fair game. No stone goes unturned, and the actions continue until the suppressive person is silenced or muzzled. And in partial defense of Scientology, I will take note that religions throughout the world, and arguably some religions today, exhibit behaviors that are comparable to this in some ways. So the Church of Scientology didn't come up with this shit. They may be one of the more notable practitioners of this form of religious puritanism, but they're not necessarily alone. Plaintiff alleges that she is a suppressive person who finds herself at the very top of David Miscavige's list of enemies. I'm not sure if that's even true, but we'll take it for the moment. I think David Miscavige probably has a lot of enemies, but you know, whatever. A former Scientologist of nearly 40 years, plaintiff has publicly departed from the church in 2013, very publicly, and became an outspoken public advocate for victims of Scientology, very publicly. Plaintiff now lives in face of the church's alleged campaign to ruin and totally destroy her and her livelihood, which hasn't been going super duper successfully, one might notice. The alleged coordinated campaign against plaintiff is well documented in the first amended complaint. For brevity, the court repeats only some of the allegations here. Plaintiff alleges defendants have engaged in a massive social media effort to spread false and malicious information about her through hundreds of Scientology-run websites and social media accounts, some of which we were able to show were Scientology-run or controlled. But some of the things they said, I'm not sure fell into the standard of defamation within the meaning of the law. So the stuff that Scientology could actually be nailed down for didn't seem like it might be defamatory. And the stuff that they couldn't be nailed down for, it's like, well, how do we know they're doing it? So there were some problems. In videotape messages posted on websites using Remini's name, it is alleged defendants enlisted dozens of current and former Scientologists to make disparaging and false claims against plaintiff. These include, now, if you could prove the Church of Scientology actually actively solicited them, then you might get something there. But of course, you have to prove that. But we'll see where the court's going with this idea. If they're posting them on their own page, you have an issue, although you could get into a 230 analysis, but I digress. These include false and defamatory statements that plaintiff is racist, which generally is non-actionable in most jurisdictions. It's too vague to mean anything. And abusive to her mother and daughter, much less vague, much more actionable. One of the videos includes plaintiff's esteemed and estranged, now deceased father, George Remini, who stated she had turned the back on the family, which, you know, well, if that's what he said, that's maybe his opinion, but okay. On Twitter, defendants allegedly create or run accounts that frequently post malicious and harassing tweets about plaintiff, repeating claims that she supports rapists and abuse her daughter. And we've discussed this with respect to the supporting of rapists, that is potentially one way you could potentially characterize some of what she's done. Do I think it's a fair characterization? Not particularly, but it is not potentially a libelous characterization. She supported someone in the past who was sued for misconduct, and one could view that as supporting rapists. I think that's a very lazy, intellectually lazy thing to do, but you know, that's what people do these days, right? So, you know, unfortunately, probably protected opinion, but we'll see if the court disagrees. And abuses her daughter. I don't remember what basis they were saying that, but it's been a while since I read the thing. Defendants allege interference is not just virtual. Plaintiff alleges defendants have hired investigators to personally stalk and surveil her, causing their fear for her safety. How do we know that those people are with Scientology? Became a big question mark in my mind. In one instance, defendants allegedly retained a security company to install surveillance technology on plaintiff's neighborhood dorm in order to spy on plaintiff. Plaintiff also alleged defendants undertook efforts to interfere with her and let her business with current and prospective business contracts and opportunities. Defendant makes a habit of harassing companies and their advertisers who work with plaintiff. Again, these are the allegations from Leah, as you can see in the citations. The issue is ongoing. Plaintiff alleges continued aggressive harassment since the filing of her complaint. This includes potential fraud flagged on several of plaintiff's cards and surveillance of friends and associates. On these allegations, other plaintiff's brings cause of action against defendant for the things we noted above. All right. Let's see how we're doing on the anti-SLAPP portion. Okay. To satisfy the first prong of the two-prong test, a defendant must demonstrate the act or acts of which they complain were taken in furtherance of the right of petition or free speech under either California's Constitution or the United States Constitution, to the extent there is a difference. An act in furtherance of a person's right of petition or free speech under the United States or California Constitution in connection with the public issue include any written or oral statement or writing made before executive, legislative, or judicial proceeding, or any other official proceeding authorized by law, any other written any written or oral statement or writing made in connection with an issue under consideration of or under review of a legislative, executive, or judicial body or any other official proceeding by law, a written or oral statement in writing made in a place open to the public or in a public forum in connection with an issue of public interest, or any other conduct in furtherance of the right to petition or the right of freedom of speech in connection with a public interest or public issue, which gets you a pretty long way. A claim might be struck as SLAPP only if the speech or petitioning activity itself is the wrong contained of, and not just evidence of liability or step towards committing some other act. So if because of the speech itself, that's the only reason we can strike for SLAPP. So that right away tells you that some of this is probably not going to be granted by the court for this reason. Maybe for other reasons, but not for this reason. So this might be a relatively narrow inquiry at this time, right? We might, again, I think it is very likely, regardless of this decision, that we will probably see a further motions to dismiss and probably another order on a motion to dismiss before too long, if I had to guess. These are just things we're going to dismiss for SLAPP reasons. If we're going to dismiss them for other reasons, then we'll do that for here. So we may not be able to determine whether or not I was right or not at this time, because the court may not speak to it, but let's see. The fact that the cause of action arguably may have been triggered by protected activity does not entail that one is arising from such. It is the principal thrust or gravamen of the claim which determines whether it applies. Under the relevant case law, this court must consider each category of defendant's alleged defamatory statements as a separate claim subject to a motion to strike. So we have to consider every single thing unto itself. This recognizes that a so-called mixed cause of action, one containing allegations of both protected and unprotected, the court must focus its actions on the protected conduct. It follows then that the court may strike improper allegations under the statute, even doing so might not dispose of the actions. So we might only be able to dispose of certain things now, because all we're considering them for is for the SLAPP reason. We're not considering them for other reasons. So we might have to allow some of this to go forward for the moment. That's what the court's trying to tell you. The moving defendant's first challenge portions of the amended complaint involving statements allegedly made about the plaintiff by defendants on social media or other online platforms. Defendants contend these claims qualify under anti-SLAPP as any written or oral statement or writing in place open to the public and further with an issue of public interest. So at this point, we're talking about Scientology and their alleged affiliates' statements concerning Leah Remini, which Leah Remini has made herself a public figure, particularly with respect to Scientology. So she is certainly, I think, a limited public figure for these purposes, which also is probably going to be relevant to the analysis, I would imagine. A public forum is a place open to the general public for purposes of assembly, communicating thoughts between citizens and discussing publicity questions. So what they're trying to talk to you about is that there's such things as public forums, there's such things as limited public forums, and there's such things as non-public forums. That would be more relevant as it relates to a cause of action relating to the government, if the government were trying to stop you from saying something. But because the legislature wrote it this way, we also bring the concept over here as well. Through public forums, though public forums traditionally encompass the public spaces like the street and park, the park is pretty much a quintessential example of a traditional public forum. So you have the right to go to the park and say whatever you want. The park. They still can regulate you on the time, place, manner, however, of course. So they can, for example, prohibit you from using sound amplifying equipment, and they can, if you have a certain size crowd, make you get a permit, blah, blah, blah. But, you can go there and say anything you want. It's a traditional public forum. It is well said that websites accessible to the public are also public forums for the purpose of the statute, citing California state-specific law. So again, your mileage is going to vary, but they say that websites available to the public are also public forums in California. Fine. I'm not even sure that makes sense from first principles, incidentally. But sure, let's go with it. The reason I say that, by the way, is because, again, I mentioned that when we're talking about public forum or traditional public forum or limited public forum or a non-public forum, we're typically talking about the government. So it's a little bit, it's slightly nonsensical to say Facebook or Facebook posts are in a public forum, because how's the government relevant to this? I don't know. I'm confused, but let's press on. It's the modern town square. The Supreme Court said at least that much. So if you had said that much, I wouldn't be so bothered, but public forum means something, at least hypothetically, but it means something different in California. That's not the first time we've heard about that, is it, B-Fish? Here, the challenge conduct occurs in posts on Twitter, now known as X, and other websites operated by defendant. These forums hardly could be considered more public. Sure. Defendants go on to argue the speech in question is an issue of public interest because it implicates Scientology and plaintiff's deliberate, year-long attempt to vilify Scientology in the public eye. Defendants also contend plaintiff's standing as a public figure, fair, makes the dispute involving her a matter of public interest, also fair. Plaintiffs see it differently, arguing the speech is mere personal attacks against her and not public interest. The relevant law does not define public interest, but its preamble states that provisions should be construed broadly to safeguard the valid exercise of rights of freedom of speech. Again, please take note, this is all being driven by California state-specific anti-SLAPP law. Your state may not even have an anti-SLAPP law, and California, for its part, is one of the broadest. So this analysis will almost certainly not apply in your state, but it applies in California, so don't overread it. An issue of public interest is any issue in which the public is interested. In other words, the issue need not be significant to be protected by anti-SLAPP. Fair enough. Members of the public, it can be a small group of the public if they care. It is enough that one in which the public takes an interest. It includes conduct that could be directly affecting a large number of people beyond the direct participants. A topic of widespread public interest. There must be some degree of closeness between the statement and the asserted public interest. In a relevant case, out of California, the California Court of Appeal established a two-part inquiry to determine whether a defendant had met its burden to show the wrongful activities fell within the public interest. First, we ask, what is the public issue the speech in question implicates? Pretty good place to start. Second, we ask, what is the functional relationship that exists between the speech and the conversation? Fair enough. So what is it that you're talking about, and how does the speech facilitate actually talking about that? So what is it? What is the topic you're supposedly talking about, and how does the speech actually relate to that in some way? Seems pretty reasonable. The relevant first step is satisfied so long as the challenged speech or conduct, considered in light of the context, may be reasonably understood to implicate a public issue, even if it also implicates a private dispute. You can tell right away where this is going, right? You know right away where this is going, that this is protected speech, because California has a very broad definition, which, you know, to be fair, is their prerogative. It isn't necessarily even wrong in the first instance. But they have, you know right away that where this is going. They're going to say, yes, this meets the first step. Only when an expressive activity viewed in context cannot be reasonably understood as implicating a public issue does the anti-SLAPP fail. Here, the court has little trouble concluding the challenged conduct falls in the public interest. Well, no duh, you've been teasing that for me about 2 paragraphs now, so I was able to pick up on your subtle clues leading me in that direction. First, at least one court of appeal has held that a large, powerful organization like Scientology may impact the lives of many individuals and itself is a matter of public interest, citing a case actually involving the Church of Scientology, which is actually slightly hilarious. There, in a different lawsuit, a person named Wollersheim alleged the court intentionally and negligently induced severe emotional injury on him through certain practices, including auditing, disconnect, and fair game. After Wollersheim obtained a judgment against the church filed an action seeking to set aside. Wollersheim then filed a special motion to strike, the anti-SLAPP. In opposing the motion to strike, the anti-SLAPP, the church argued its practices were not public issue. Although the church was a plaintiff, the court reasoned the church's actions arose from Wollersheim's lawsuit against the church. It concluded the record reflects the fact that the church is a matter of public interest, as evidenced by media coverage and the extent of the church memberships and assets. Furthermore, the underlying cause of action concerns a fundamental right, the constitutional protection under the First Amendment, religious practices guarantee, and addressing the scope of the protection, concluding the public has a compelling secular interest in discouraging certain conduct, even though it qualifies as religious expression of the Church of Scientology. Plaintiffs attempt to distinguish the instant case from Wollersheim. This is now referring not to this case, I think, but other case fighting, I think. Not sure, though, which case they're actually taking. When they say the instant case, which case do they actually mean? I guess they mean the one involving Remini, but I really wish they had made that a little bit clearer, because, like, wait, how far back are we going in this instant? All right. Anyways, the court agrees. The plaintiff's attempt to distinguish this case versus Remini from Wollersheim fails flat. Plaintiff correctly argues the analysis of the speech in Wollersheim was somewhat reversed because the church was the non-moving party arguing the challenge speech was not public. But the point holds true. The court agrees the public holds a general interest in the Church of Scientology, which includes the church's operations and the treatment of members and former members like the plaintiff. As a high-profile organization with a past and present celebrity members, the church has long garnered interest and imagination of the public at large. These stories often play out in a public forum, whether it be Twitter, which we're going to call a public forum for the moment, television, or in this case, a courtroom. Also, none of those are public forums, but okay, sure. It also is a courtroom is not a public forum. Please don't actually try this, but please don't actually try this, but just try going into the middle of a courtroom and like start talking about things and let me know how it works out for you. Clue, it won't end well. Please don't do this. It is also important to consider that plaintiff herself is a widely known figure who attracts widespread interest. As already noted, the plaintiff became known for her role in television sitcom The King and Queens from 1998 to 2007. This notoriety made her the public face of Scientology until she publicly departed in 2013. Since leaving Scientology in much to the church's ire, plaintiff has attempted or actively produced media critical of Scientology. She sure has. In 2015, plaintiff produced a New York Times best-selling book called Troublemaker, Surviving Hollywood and Scientology. She's also produced and hosted an A&E documentary series entitled Leah Remini, Scientology and the Aftermath. She is now a tireless advocate for victims of Scientology, and she's appeared on various television shows and podcasts to do so, yet to appear on Uncivil Law maybe later. Although if I have her on, I suppose I also have to extend an invitation to the Church of Scientology to also appear on my channel, which would be slightly hilarious if they accepted. So if you are Leah Remini and or the Church of Scientology and you'd like to appear on Uncivil Law, please let me know. My contact information is Kurt, K-U-R-T, at uncivillawllc.com. I look forward to hearing from you. Throughout this lawsuit, she seeks to vindicate others who wish to expose Scientology abuses, including journalists and advocates who may feel free to hold Scientology accountable without fear they'll be threatened into silence. In other words, this is not a private dispute. When viewed in context, the First Amendment complaint, Kurt will mediate the dispute. That's right. My powers of mediation are so great. I'm going to bring Leah Remini and the Church of Scientology together. We will strike peace and they will emerge as friends. My powers of mediation are just that good. Plaintiff's arguments to the contrary fall flat. In opposition, plaintiff relies on a case from the Texas Court of Appeals. Therein, a wife of former prominent Scientology brought action against the church alleging a 3-year campaign of ruthless aggressive surveillance, insults, and harassment. The church moved to dismiss the complaint under a Texas state law analogous to the California Anti-SLAPP statute, arguing the action challenged protected activities. The court rejected the argument. The court held that the harassing conduct complained of lacked any direct relationship to a public interest. Importantly, the court reasoned the plaintiff was neither a public figure nor a limited purpose public figure for the purposes of that particular lawsuit. Rather, the plaintiff herself was never a member of the Church of Scientology, did not join her husband speaking out about Scientology issues, and did not take a public position regarding Scientology. The records showed that the plaintiff had attempted to earnestly avoid the public controversy between her husband and the church. Thereafter, the court determined Scientology defendants failed to meet their burden of demonstrating by preponderance of the evidence the plaintiff's claims arose from exercise of the rights of freedom of speech of association. Here, unlike in SLAPP, plaintiff herself is a former Scientologist who now actively advocates against the church, often publicly through various mediums. This can hardly be an attempt to earnestly avoid the public controversy. Fair. To summarize, the church is a high-profile entity speaking on a high-profile figure. Plaintiff is a high-profile figure speaking on a high-profile entity. Plaintiff's speech is at times responsive to or provoked by defendant and vice versa. By engaging in back and forth, purposefully public battle against each other, the parties have made their issue one of significant public concern. Therefore, plaintiff's allegations concerning defendant's online statements about her arise from the protected activity. The defendants have therefore met their burden for the speech to be implicated in its portions. Therefore, we move on to step 2. Okie dokie. The court now turns to allegations in the First Amendment complaint detailing defendants' alleged interference with plaintiff's media relationships. There was some evidence along these lines, and there was some potential here. So we'll see. I'm not even sure the court's actually going to try to deal with it in terms of sufficiency at this point, or whether or not it's just going to say anti-SLAPP isn't the issue. Let's see. The claims at issue are the following. Plaintiff alleges defendant sent disparaging and threatening letters to ABC News and other media who were promoting plaintiff's books. She alleges that defendants organized a barrage of letters sent to media executives in protest of her release of the Aftermath series. Scientologists also sent texts and emails to anyone involved in this, again citing the First Amendment complaint. The court is not saying these things are true, merely that they're basically assumed to be true for the purposes of the discussion. Yeah, everyone please go vote for Rich Hogue. The link is in the chat. Please take the time to click on that and vote for him. There are 200 of you here. Every one of you can go vote. Please go vote for Richard Hogue, our friend. It would be an appreciated thing. Before plaintiff's appearance on Conan O'Brien to promote her book, defendant sent Conan O'Brien objection to her appearance, claiming plaintiff was speaking out against Scientology for fame, money, and attention, which, I mean, probably, at least partially, but then again, what's necessarily wrong with that? Defendants allegedly sent letters to the president of A&E accusing plaintiff of inciting murders of a 24-year-old Taiwanese Scientologist at Australia headquarters. We've read that as well, and the evidence supporting that is that she was inciting in any sense is questionable at best. Finally, in letters to Autoboom and affiliates, defendants asserted that advertising on Remini's podcast would promote religious hate. Which, probably. Defendants argue these allegations fall under the Code of Civil Procedure, which protects other conduct in furtherance of further speech or petition rights in connection with a public issue. Cause of action arises from protected activity if defendants' acts underline the cause of action and on which the cause of action is based, or it acts in furtherance of defendants' right of petition or free speech in connection with a public issue. In opposition, the plaintiff contends that defendants have failed to meet their burden to show the harassment of Remini and Remini's employment and sponsors attacked are tethered to any issue of the public interest. Okay, I buy that for the purposes of an anti-SLAPP analysis. Here, under this discussed before, is the same. Under the relevant first step inquiry, the interest of the public interest implicated by speech at issue is the dispute over a plaintiff's relationship with Scientology, which necessarily includes Scientology's alleged campaign to ruin plaintiff's career. The alleged communication were also largely directed to public figures with apparent authority over public productions themselves. The public undoubtedly has an interest in learning about and discouraging retaliatory conduct by religious organizations that occur in a non-secular context. In a non-secular context. Isn't this a secular context? I'm confused. Second, the functional relationship between that speech and the broader public conversation about Scientology is largely one and the same. Defendants' alleged letters and other communications to media figures with control over plaintiff's media ventures underlie the running dispute between plaintiff and the church, a matter which, as has been discussed, the public themselves is interested in. The recipients of these letters, by author and influence, themselves pose power to shape public perception of both plaintiff and the church. In that sense, they too contribute to a broader conversation. Therefore, plaintiff's allegations concerning defendants' alleged interference with media relationships arise from defendants' protected activities. Defendants have therefore met the burden for the speech implicated in these portions. That switches to prong 2 of the analysis. Fine. Finally, the court turns to the third category of speech challenged by defendants, which they deem to be pre-litigation surveillance. Based on issues with the plaintiff, defendants contend they were in pre-litigation stance as early as 2013. Any surveillance that followed, defendants argue, was pre-litigation investigation in connection with their right to petition and also was protected. Thank you for voting, David. And thank you for voting, MS Jackson. Plaintiff alleges that she was followed by private investigators hired by defendants in 2015 while in New York to promote her book. Defendants allegedly hired the investigators from International Investigative Group to surveil and follow her while she was in New York filming. Defendants retained a security company to install surveillance technology at plaintiff's neighborhood home under the guise that plaintiff herself had sent the company. Defendants directed individuals to follow and harass podcast producers until those producers grow so fearful that iHeartMedia made the decision to terminate the relationship with plaintiff. Since the following lawsuit, defendants have also allegedly surveilled Mike Rinder, who co-hosts The Aftermath. Courts have adopted an expansive view of what constitutes litigation-related activities within the relevant section of law. Statements made in preparation for litigation or anticipation of bringing action fall within these categories. Parties, however, have not cited any authority applying the first prong of anti-SLAPP analysis to claims based on surveillance purportedly attempting litigation. So this is a bad fit. What you're trying to do right now is a bad fit for what is happening. Defendants cite to the case of Chishin versus City of Morgan Hill to support their argument that this is pre-litigation surveillance that's protected, but the case is mostly an opposite, which basically says exactly the wrong thing. Chishin did not address the first prong of anti-SLAPP, instead addressing the merits of a Section 1983 claim. Under the second prong, the court stated the proposition that a non-petitioning conduct is within the protected breathing space of the right to petition. If the conduct is incidental to or reasonably related to an actual petition or actual litigation, or to a claim that could ripen into a petition or litigation, and the petition, litigation, or claim is not a sham. Thank you for the 200 of you currently watching. Just a friendly reminder to please hit the like button. It costs you nothing and probably helps with the channel. I don't know that it does, but it can't hurt. Defendants assert that they were in pre-litigation stance at the time of the alleged surveillance. The contemplated litigation arises from a defense allegation, or plaintiff's allegation. Defendants accused her of filing a false police report and then attempting to extort Scientology. Defendants do not dispute that. In fact, they provide a copy of the article, apparently published by the church itself, which includes the church's claim that plaintiff made a fraudulent missing person report. A fraudulent missing persons report on David Miscavige's wife, Michelle Miscavige, who is, not been seen in public in something like, how long has it been? Like 20 years or something ridiculous? The church's article goes on to state that after informing the media of Remini's false report and lack of scruples, Remini's attorney sent the church back-to-back extortion demands for $500,000 and $1 million, respectively. Defendants, however, provide no evidence showing when plaintiff actually made the litigation demands. The implication from their argument is that these demands occurred in 2013, which prompted defendants to begin surveillance in anticipation of litigation. But plaintiff's evidence shows otherwise. In actuality, plaintiff made her demands, the so-called extortion, in late 2016, after the surveillance had already begun. The court is mindful that some of the allegations involving surveillance occurred after 2016. But if defendants were willing to surveil plaintiff before the threat of any litigation occurred, they are hard-pressed to demonstrate any protected pre-litigation surveillance after the fact. This is especially true because defendants provided no evidence, declaration or otherwise, suggesting they reasonably contemplated litigation in good faith at any time. The California Supreme Court has explained that in deciding whether the initial arising from requirement is met, a court considers the pleadings and support and opposition affidavits stating the fact on which liability or defense is based. Court does not mean to suggest that moving defendant must always submit evidence in prong one, but it'd be helpful. You know? But here, the protected conduct is not apparent on the face of the amended complaint. On this record, the court can only conclude that attempts by defendants to attribute the surveillance with good faith beliefs in litigation is unsupported by evidence and contradicts common sense. Fair enough. That of course, presupposes it's the defendant that's doing the surveillance, although they've admitted to some of that at least in 2013. So some of it is theirs, which maybe is enough to bootstrap the later surveillance. But, you know, so some of it was theirs. That thing in early as 2013, maybe it's enough to keep it alive through a motion to dismiss. Fair. Defendants have submitted a supplemental declaration from Lynn Farney, including an email chain between Mike Rinder and a person only identified as Laura. The email chain was produced in discovery in a separate lawsuit. In one email, Rinder states that Leah Remini is looking for a lawyer to possibly represent her against the church. The evidence creates more questions than answers. It's not clear from this bare line email how Rinder knew plaintiff was looking for a lawyer, what the lawsuit against the church would be based on, or if the church had knowledge of the lawsuit. This is plainly insufficient to support the burden to establish that challenge conduct arises from protected activity. For these reasons, there's insufficient connection between the alleged surveillance and the public interest. The court sees no public interest in surveillance of private citizens, even celebrities, under an unsupported suspicion that litigation might occur. All right, so they're presupposing, so the court is presupposing that the litigation has happened, at least for the purposes of the anti-SLAPP. Which, you know, fair enough. So we might be able to bring it up separately in a motion to dismiss, but we're just trying to figure out whether or not, assuming it's true, do we get through the anti-SLAPP? Okay, I appreciate the court's segmented analysis. Although it seems like maybe the court is hinting at the idea, that it is considering the idea that maybe there's enough evidence to consider that the more recent conduct is also the Church of Scientology because they had her under surveillance since 2013. It's enough to ask the question. So maybe it's enough to get past the motion to dismiss on the surveillance and stalking stuff, which, you know, if so, good for them, I guess. Good for Remini. Acquiring portions of the FAC challenged by defendants in this category, to the extent they're based on allegations of surveillance by defense or its agents, fail on prong one. Hence, the analysis stops here, and the special motion to strike these particular allegations are denied. I have no particular problem with any of that. So that's fine. So we want to allow that stuff to survive the anti-SLAPP. I have no problem with this analysis. This seems fine to me. Having concluded the claims challenging the allegedly false online statements and interference are subject to anti-SLAPP protection under claim 1 or prong 1, court now turns to the merits under prong 2. The burden of showing a probability of prevailing on the claim rests with plaintiff. To establish a probability of prevailing, the plaintiff must demonstrate that the complaint is both legally sufficient and supported by such, this is where it's key, supported by such prima facie evidence showing of facts to sustain a favorable judgment, right? That's where things tripped up for me. Like, you got to have some evidence. You got to have prima facie, your prima facie case. Defendant stalked me. How do you know that? Okay, I saw a bunch of surveillance vans. Okay, how do you know it's defendant? Right? What is your prima facie fact? As the case where it's like some of the prima facie Like, how are you establishing that this is the defendant? Scientology. So let's see what the court says about that. For the purposes of the inquiry, the trial court considers the pleadings and evidentiary submittings of both plaintiff and defendant, not that there really are any at this stage, but never mind. Though the court does not weigh the credibility or comparative probable strength of the evidence, it should grant a motion if, as a matter of law, defense evidence supporting the motion defeats the plaintiff's attempt to establish it. In making the assessment, it's the court's responsibility to accept as true evidence favorable to the plaintiff. Evidence. The evidence is true. The conclusions, not as much. The plaintiff need only establish that his or her claim has minimal merit to avoid being stricken by SLAPP. Doesn't sound like very much. As to the second step, yeah, if the dark vans were covered in COS vinyl wrap, that would help a lot. As a second step inquiry, the plaintiff seeking to demonstrate the merit of the claim may not rely solely on the complaint, even if verified. Right. Just because you said it, you know, just because you said the words, it must be based on competent admissible evidence, such as you yourself saw it, would be fine. But what did you see or hear or what? Or, you know, you can't just say a thing. You can't just speak it into existence. No speculation. Again, we're not looking for much here. We're just looking for something, anything. And we're even assume it's true, right? You don't have to prove it's true. We'll just assume it's true. You give us something, anything. Plaintiff brings her sixth cause of action for defamation and seventh cause of action for defamation by implication, eighth for false light, which I imagine will disappear into the defamation. The elements of defamation are the following: publication, false, defamatory, unprivileged, has national tendency to injury. Well, boy, oh boy, that sounds familiar. A statement is defamatory when it tends to directly injure a person with respect to that person's office, profession, trade, business, either by imputing to the person's general disqualification in those respects, or by imputing something with reference to office that has a natural tendency to lessen its profits. Statements about a person's business or trade. In case where a plaintiff seeks to maintain an action for defamation by implication, plaintiff must demonstrate that his or her interpretation of the statement is reasonable. The implication or implications to be drawn convey defamatory facts, not opinions. The challenged implications are not substantially true, and the identified reasonable implications could also be ones reasonably deemed defamatory. False light is a species of invasion of privacy based on publicity that plaintiff faces the plaintiff before public in a false light that be highly offensive. Defendants argue that these are barred by a statute of limitations. They're non-actionable statements of opinion, non-actionable statements of truth, were not made with malice. Let's contend as to those things. Yeah, even if it was a member, you'd have to have some evidence they were directing it. Yeah, even if they're a member of Scientology, you'd have to have some evidence that the Church of Scientology is directing it. That doesn't work, right? That's because sometimes people act on their own. Now, if the person who is traced back to Scientology has some sort of office or position or something like that, then, you know, fine. But, you know, the mere fact they're a member isn't going to do the trick. I'm a member of a lot of organizations. You know, it doesn't necessarily mean I'm acting on behalf of any of them in a particular act of my life. Same is true for you, I assume, as well. Defendants argue the plaintiff's claims fail because on the face of the complaint, the unverified publications occur more than one a year before. Defendants also argue those paragraphs are time barred based on evidence in the declaration. Thus, for the purpose of the section, the task is to identify any of these claims are barred because they occurred before the relevant time period. Plaintiff for Herburn correctly notes the evidence that posts have been made and published about her after 2022 and corroboration in the opposition claims. Such claims, whether about websites or Twitter posts, are timely for the purposes of the motion. In Indeed, rather than by addressing every challenge claim, which may be timely, the court instead focuses its analysis on ones that are plainly or not. Where not otherwise stated, plaintiffs met their burden to establish prima facie evidence of timely claim. And here are some procedures that are untimely on their face and fail to produce prima facie evidence. So here's a bunch of stuff that happened that is out of the statute of limitations period, which I did not separately analyze, incidentally, in my prior legal analysis. Second, regarding the allegations in paragraphs of 90 and 91, defendants present evidence that Scientology videos were first posted online in February 2022. In addition, the articles and videos referred to at paragraph 115 were made available at freedommag.org between September 2017 and February 2022. Plaintiff does not dispute defendant's evidence showing the statements also occurred outside limitations, therefore they're also barred. Okay, so we're going to go through some more statute of limitations analysis, which I'll skip. So I'll skip that because I didn't really provide any analysis on that. So some of the stuff gets dismissed for statute of limitations. Fine. Next, defendant argues that many of the allegations purportedly giving rise to plaintiff's defamation cause of action are either unactionable statements of opinion or truth. The court agrees with the particular argument to some degree as noted above or below. Because an actionable statement for defamation must contain a provable falsehood, courts distinguish between statements of fact and statements of opinion for the purpose of defamation liability. Although statements of facts may be actionable as liable, statements of opinion are constitutionally protected. Though mere opinions are generally not actionable, a statement of opinion that implies a false assertion of facts is actionable. Further, it is not the literal truth or falsity of each word or detail used in a statement which determines whether or not it's defamatory. Rather, the defamation questions whether the gist or sting of the statement is true or false in substance. In determining whether a statement contains a or implies a provably false assertion of fact, courts apply the totality of circumstances. Under totality of circumstances, first the language of the statement is to be examined. For words to be defamatory, they must be understood in defamatory sense. Next, the context in which the statement was made must be considered. The pertinent question is whether the reasonable fact finder could conclude the statements as a whole or any of its parts directly or made or sufficiently implied a first false assertion of fact. Whether challenged statements convey the requisite factual imputation is ordinarily a question of law for the court. Okay. The claims giving rise to the alleged defamation in the First Amendment complaint are numerous. Indeed, it's hard to keep track of. The First Amendment complaint incorporates by reference all prior allegations, while also weaving separate claims into single paragraphs or lines. It employs a disfavored shotgun or chain letter style of pleading, where each claim for relief incorporates by reference all preceding paragraphs, which often masks the true cause of action. That's pretty common, though. Making matters more difficult, the parties routinely refer to defamatory statements in the abstract or general sense. The court reminds the parties that under the relevant case law, each separate claim subject to the motion to strike must be treated as that separately, which, fair enough. Be that as it may, identifiable allegations include that plaintiff was a bigot, racist, abusive, pro-rape, and promoted hate speech, among others. Plaintiffs have argued in context these defamatory statements are not mere opinions and are false. The courts address them specifically as follows. Okay. As to violence against Jehovah's Witnesses. On the Stand League website, defendants published an article titled, again, this is all assumed to be true, again, for the purposes of this, remember, this court is not saying these things for a fact at this time. It's just saying what is true and whether or not it seems like there's a chance they can win based on the allegations. The court is assuming the truth of the allegations and assuming the facts relevant to that to assess probability. So it's somewhat in the dark, but that's by design. So just bear in mind. On the Stand League website, defendants published an article titled, Are Leah, Remini, and Amy responsible for waves of violence against Jehovah's Witnesses Kingdom Hall? That arose from an episode of The Aftermath in where the plaintiff allegedly attacked Jehovah's Witness, provoking a wave of violence against Jehovah's Witness Kingdom Halls in Washington in 2018. Plaintiff contends there's no connection between her show and the violence against Jehovah's Witnesses. She shows the aired on November 13th in 2018. And the 4 out of 5 arson attacks happened before the date. But that misses the issue. It is difficult to conclude the title of the article by itself implies a provably false assertion of fact. The title proposes the statement as a question. While the context within the article might prove helpful, plaintiff fails to disclose or identify any defamatory statement actually contained in the article. Concerning this plaintiff, the plaintiff has not met their burden, therefore that is stricken. Okay, so she loses that. So, yeah. It's difficult to conceive that the title article implies a provably false assertion of fact. The title proposes a statement as a question. Yeah, so she loses that. As to inspiring praise of Hitler, who I've heard some, to borrow a Norm Macdonald joke. You know, the more and more I hear about Hitler, the less and less I like that guy. Defendants published another article about As the World Remembers the Holocaust, bigot Leah Remini inspires praise of Hitler. The story arose from a tweet by plaintiff accusing the church of stalking and harassing her. As follower responded to tweet with the following reply. In the 1940s, there was a certain European politician who had big ideas. Who could we be talking about? He had the right ideas, but went after the wrong groups. Scientology is a plague and needs to be exterminated. Okay, all right. That's a bold take. Cotton. Again, an allegation article that they might have inspired praise of Hitler standing alone is not provably false, therefore it disappears. As to the rape apologist. After plaintiff testified for Paul Haggins at his rape trial, defendants posed an open letter to the game show network claiming the network employed a rape apologist as their host. The hate monitor tweeted a photo of plaintiff with a tattoo on her forehead reading, "I heart rapists," and wearing clothing supporting rapists. The text of the tweet included the hashtag Remini loves rapists. The doctored photos here, while highly offensive and inappropriate, can be deemed only appropriate. Or can be deemed only a parody. A fact finder cannot reasonably conclude the images make or imply a false statement of fact. Wow, I don't know about that one, but okay, court. Plaintiff goes on to argue the posts asserted as fact provide no factual basis for the statements, but the posts identified by plaintiff in support of the argument are not identified within the First Amendment complaint. As is true within the summary judgment motion, the issue in an anti-SLAPP are framed by the pleadings, which is true. Because the issues to be determined are framed by the pleadings, we will not insert into pleading claims for relief based on allegations of activity plaintiff have not identified. It's not our role to engage in what would amount to redrafting of a complaint or to read that document as alleging conduct that supports a claim that has not been fact specifically alleged, and then assess whether the pleading could have survived if differently drafted. Therefore, the post cannot survive. Going further, plaintiff has not produced evidence to conclude the post identified in the First Amendment complaint make or imply a false assertion of fact. Again, the posts are more improperly considered parody. Again, I don't think I'd agree with that, or I don't think I'd say that they're parody. I just say that I think they're protected opinion based on other factors, but I don't know about parody. No reasonable person viewing them would consider them to mean plaintiff actually loves rapists. Defendant proved no factual basis for saying plaintiff loved rapists is exactly the point. No one viewing them could take them literally. I don't know about that one. I assumed they were to be taken literally, and then I just assumed that they were protected, so maybe I'm not a reasonable person, though. I don't know. Therefore, they're dismissed. Yeah, I would concur in the judgment. I would concur. I come to the same conclusion, but for very different reasons. As to abusive employer. Plaintiff contends defendant sent fake journals to the set of People Puzzler, asking about claims the plaintiff allegedly abused in the workplace. but the allegation does not appear to actually identify any defamatory statement. That makes it impossible to analyze. More of the motion is limited to pleadings, because an unidentified statement cannot be defamatory if files. Okay. As to KKK and neo-Nazis, defendants allegedly made a video comparing plaintiff and A&E Network to the Ku Klux Klan. Also in an open letter to the Game Show Network, defendants expressed concern over plaintiff hosting on the network and asking what's next. A game show hosted by a KKK leader? Neo-Nazi Jeopardy? Neo-Nazi Jeopardy sounds interesting. I think I would tune in for that. I can just imagine, right? The parody sort of writes itself. Maybe it'll be less fun in the real world, but something about maybe it'll be less fun in the real world. But somehow the idea of neo-Nazi Jeopardy just struck me as amusing. A bunch of neo-Nazi contestants with a neo-Nazi host sounds like something out of a parody from an SNL skit or something. I don't know. Maybe it would be less funny in the real world though. Plaintiff argues these statements, when viewed in their specific factual context, are also provably false. But then again, plaintiff fails to explain that in a factual context or provide evidence to meet the prima facie burden. Therefore, they are stricken. As to racism, in videos using former Scientologists, defendants allegedly made claims the plaintiff was racist. The Court of Appeals explained the term racist is also a word that lacks a precise meaning. There's no bright line rule as to whether claims of racism can form the basis of defamation. Instead, like defamation tests more generally, the context in which the statement's made controls. Yeah. As now, the pattern plaintiff only addresses the racist statements in sweeping terms, but she's not actually identified what was said and the implication was racist nor the context. She cannot say to have met her burden. Accordingly, it is stricken. Statements by plaintiff family show that she's a liar and stole from them. Defendants allegedly stated in videos that plaintiff was abusive to her mother and daughter. In another video, defendants used and manipulated Miss Remini's estranged and now deceased father and third wife to make false statements about Miss Remini, including she's a liar, that she only won her name in the news. I don't even know what that means or why that's necessarily bad. That she would not help pay for cancer treatments. That's a lot more sus. That she turned her back on her half-sister when she was in the hospital, and she ransacked her dying mother's apartment and has no morals. Plaintiff flatly denies she ever abused family members, or she turned her back on her father or sister when they were ill, or she ransacked her dying grandmother's house. Plaintiff attests that she housed her father and paid for his treatments while she had cancer, paid her sister's bills when she was in the hospital, and allowed father to take what he wanted from her grandmother's apartment. She also disputes the allegation of poor relationship with her daughter. First, the court would agree that these claims are provably false. Through a fact-finding process, one could determine plaintiff had in fact been abused to the mother and daughter, paid for the cancer treatments, or ransacked the dying apartments and turned their back on family. A separate issue raised by defense is whether the statements from plaintiff's family members can give rise to defamation. Excuse me. Defendants argue they have no reason to know the statements were false, no obligation to fact-check the statement. In St. Eminent, the United States Supreme Court that held in part that failure to verify information does not demonstrate actual malice. But St. Eminent does not totally shield the defendants here. Even in a public figure case, defendants' knowledge of falsity or reckless disregard can be proved by circumstantial evidence. Such factors as failure to investigate facts or anger or hostility may indicate the defendant had serious doubts about the truth. Finder of fact must determine whether the publication indeed was made in good faith. By the way, if anyone out there has good recommendations for a dehumidifier for my home, I have a very small mini one, but I would like a more powerful dehumidifier. So if anyone has any recommendations for a good dehumidifier, please let me know. It's too humid in here and the air conditioning is not doing enough. I want it drier. Okay, where was it? Plaintiff provides extensive evidence defendants made publication with the least reckless disregard. Defendants posted videos at Leah Remini in the facts. Leah Remini, thefacts.org. But plaintiff insists defendants knew they were not facts because she told them. That's not what. Plaintiff attests that she communicated to Scientology how difficult her relationship was with her father, and she continuously wanted him to establish a relationship with him and provide support to him. And Scientology has documentation in her personality and confidential files that reflect this. When considered in context of a calculated attack, there's prima facie showing of clear and convincing evidence. Accordingly, plaintiff has met her burden to establish the validity of the minimal merit standard. Really? Okay. Not sure I agree with that, but fine. Come up to Calgary. Maybe if I find myself a Calgarian woman who wants me to move up there. Pence also argued plaintiff defamation claims fails because as a public figure, plaintiff cannot establish actual malice. They contend that even if plaintiff can prove some of the defense factual assertions are false, she'll never be able to surmount her burden, given each one was based on a reliable source, such as a family member or former colleague. As an initial issue, this court must determine if plaintiff is a public figure. It concludes that she is. You have some hot cow babes up here too. Hey, find me a hot cow babe and I'll move up there, man. I'll tell you what, man. That rationale for such differential treatment is, first, the public figure has greater access to the media, and therefore greater opportunity to rebut defamatory statements. And second, those who become public figures have voluntarily done so and invite attention and comment. As discussed earlier in the reading, plaintiff is a public figure. She's a two-time Emmy Award producer, actress, and New York Times bestselling author. Plaintiff became known for her role in the popular television show The King of Queens. She was the public face of Scientology. She eventually made intentionally public departure from the church. Since leaving public, plaintiff has gone on to produce media critical of Scientology, apparently too much fun, fare, and attention. Her book was a New York Times bestseller. I'm really having trouble spelling my words today. I'm stumbling over my words just a lot today. Just having problems with the pronunciation. Today, I'm just having a rough day, man. I mean, I stumble over my words, but it just seems like a lot today. She now publicly advocates against Scientology and appears on various television shows and podcasts to do so. At the very least, plaintiff contends that she is a limited public person for purposes of public controversy about Scientology. Next issue is whether plaintiff has made a prima facie showing of clear and convincing evidence defendant's statements were made with knowledge that they were false or with reckless disregard to whether they are false or not. As already discussed, plaintiff has done so. As a suppressive person, plaintiff has detailed in her declaration the lengths defendants have gone to harass and humiliate her. Mike Rinder, a former Scientology and past member of its Sea Org, provides a declaration that corroborates defendant's bad faith. As a former Scientology official, Rinder states he's well aware of Scientology's methods to quell the voices of those who least speak out against Scientology. Okay, so you want to go forward on Rinder's declaration? That he's aware of this is how Scientology's past and practices operate? Okay. It feels a little bootstrappy, but all right. I mean, fine. It sounds slurry. Yeah, and it's not a good day for me today. Yeah, I trip over words sometimes, and sometimes I have problems, and today I'm just tripping over a lot of words. Not my peak day, man. Not my peak. It definitely sounds slurry. I agree. Maybe I'll try to slow down a little bit. The court now turns to plaintiff's cause of action for intentional infliction of emotional distress. A cause of action for intentional infliction of emotional distress exists where there is extreme and outrageous conduct by the defendant with intention of causing or reckless disregard of the probability of causing emotional distress. Plaintiff's severe or extreme emotional distress and actual and proximate causation of emotional distress by defendant's outrageous conduct. A defendant's conduct is outrageous when it is so extreme as to exceed all bounds of that usually tolerated in a civilized community, and when defendant's conduct must be intended to inflict the injury or engage with the realization that the injury will result. Severe emotional distress means emotional distress of some substantial quality or enduring quality that no reasonable person in a civilized society should be expected to endure it. Whereas here the plaintiff is a public figure and the IIED is based on speech, she must prove actual malice. Court notes the first part of the basis of the IIED claim is presumed by defendant's pre-litigation surveillance. I'm only on page 31 of 42 too. I'm already tired of reading this. This is very lengthy, 42 pages. I didn't really realize what I was getting into by reading this. Got 11 more pages of this, man. Court notes the first part of this basis of IIED is presumed by defendant's pre-litigation surveillance. Because defendant did not meet their burden on the conduct, it need not be addressed under point 2. Here, where plaintiff's allegations had not already failed for a reason discussed above, the court concludes plaintiffs has met their burden to establish extreme and outrageous conduct. Okay, I buy that. That makes sense on at least this stage of the proceedings. It's dense. It is dense. It is. Plaintiff and Mike Rinder detail the thorough, harsh, and unrelenting campaign against plaintiff under the auspices of fair game. Plaintiff's evidence also demonstrates that this caused her extreme emotional distress, as plaintiff attests in her declaration. The decades-long I'm going to take off my hat because it'll make me a little. The hat is very warm. A little muggy in here right now. The decades-long coordinated harassment of me. Next page. Plaintiff has incurred substantial economic expense to protect her and her family's physical and emotional health. From her time in Scientology, she knows they'll stop at nothing utterly to destroy her life. Considering the evidence, once again, which the court must accept as true for the purpose of the anti-SLAPP, plaintiff has established the requisite minimum merit of claim. Yeah. Is any of this interesting at all? I mean, there's like no one chatting. There's like one chat a minute. There's one chat a minute. And it's like there's no one. 200. Is any of this interesting at all? Let's just skim through and see if there's anything else that matters. Let's see. The plaintiff stalking cases of actions based on non-protected surveillance. Go through the elements of stalking. They're constitutionally protected. Speech that constitutes harassment is not protected. It's not difficult to imagine a credible threat based on the alleged surveillance. I like your voice, but not listening. I don't know what that means. Plaintiff alleges defendants interfered with her contracts with iHeartMedia and Audio Boom. These are only 2 contracts expressly alleged in the cause of action. Blah, blah, blah. Okay, so they are going to allow it to go forward on the intentional infliction of emotional distress. So basically, it looks like they're crediting Rinder's. They're crediting Rinder's declaration for the idea that this is how Scientology has acted to conclude that this is Scientology's action. Okay. I mean, I understand that. That's fair. Not listening to the content, blah, blah, blah in your voice. The judge is back what in the judge is back in Crumbly? Crumbly judge back? I could use the break. No, law and crime is still showing. The deliberation is ongoing. Jury in Crumbly's been out for 7 hours. I would have thought they would have come. My bet was that they were going to come back about an hour and a half ago. So I lost my bet, I guess. So they're going to allow the intentional infliction of emotional distress claim to go forward, at least for the moment. Yeah. The court has expressly identified various paragraphs throughout the First Amendment complaint that qualifies protected speech and lack minimal merit. According to the special motion to strike is granted as to that. To the extent otherwise denied, attorney's fees. Given the mixed nature of this ruling, any party may file a notice for attorney's fees if they'd like to do so. Make no finding at the time whether there actually is a right to attorney's fees. The right to attorney's fees will be determined in a hearing. Be that as it may, any party who files a motion should keep in mind the standards for requests, and therefore it's allowed to continue for the moment. No, it's still showing a long crime. It's still showing a long crime that there is no verdict. So, all right, well, I'm done with this for the moment. I'm done for this, so I'm going to stop talking. So, yeah, the court, so I was slightly surprised, I guess. I was surprised by the rationale for allowing, I was surprised by the rationale for dismissing the claim regarding Leah Remini as a rapist. I'm surprised by the rationale. Right decision, I disagree with the rationale. I'm surprised by the court's reasoning as it relates to the, I'm not surprised by the court's reasoning as it relates to intentional infliction of emotional distress. I'm partly surprised by the court's decision to allow the intentional infliction of emotional distress, the intentional interference to go forward. That's good. All right, so I'm going to stop talking now. I need a break, and I'm not at my best anyway. So I need a break, and then I'm going to actually go like do a job that someone actually paid me. So I need to sign off. But I've had fun. And we'll definitely keep following this case as we need to. So we'll see what we can do. Until then, my friends, I've been Uncivil Law. Hope all's well. Cheers, my friends, for now, and goodbye.